Thank you for choosing View Legal to implement your estate planning arrangements. My name is Tara Lukey and I'm joined with Matthew Burgess. The purpose of this video is to step through the key provisions of your will. Throughout the video, we'll show you a sample will on the screen, which will be very similar to your will. During the online meeting, your View Legal lawyer will point out any aspects that are different to the sample will.
Hi, my name's Matthew Burgess. The purpose of the online meeting that you'll attend is to make sure that all of your instructions have been reflected in the documentation, step you through the documentation and get you comfortable with it, and where necessary, get any changes made before we send the material to you for signing. One thing to note is that the entire meeting will be recorded, so if you've got any concerns at all with that approach, please make sure you raise them at the start of the online meeting.
Turning to your will, I want you to make sure that we've got your name and address spelled correctly. If there are any changes, please mention it to your View Legal lawyer during the online meeting. The same goes for any other names throughout the document. Please let us know if they're not correct.
You'll see in the overview section that the will, as soon as you sign it, will automatically revoke any previous will that you may have done. The other really big thing to understand is that the will only regulates assets that you own personally. Now, what this means is that if you own anything via a superannuation fund, assets inside a trust or a company, or indeed assets that you own personally but you own them as joint tenants with someone, they will not form part of your will. If you've got any concerns in this regard, make sure you raise them as part of the online meeting.
I'd like to talk to you about the definitions section. Throughout the will, you might see that there are particular words that are capitalised in an unusual place. This means that they are defined terms and their meaning is set out in the definitions section. I'd like to talk you through some of those key definitions now. The first one is the gift over provision. If you've nominated a gift to go to a particular person in your will and that person has not survived you but has children who have survived, then if the gift over provision applies, then those children are going to take the gift of their deceased parent. You might see throughout the document that there are comments that the gift over provision does not apply. This is because there is a presumption in the document that the gift over provision does apply unless specifically stated. Another useful definition is LPR, which stands for Legal Personal Representative. This just means you're executors and trustees of your estate. You'll also see net estate used throughout the document. This just means all of your assets at the date of death, minus the liabilities, which are available for distribution. You should also take note of the definition of personal items. This includes any household and personal items such as jewellery, and also includes your motor vehicle. We've highlighted some of the key definitions, but you really should take the time to look through them all and get familiar with them.
The first substantive clause of your will relates to the executor and trustee. Now, this is the person that you appoint to actually regulate the entire operation of your will. Their main responsibilities will be to actually find the last version of your will, the last original will, collect in all the assets of the estate and pay any liabilities. Depending on the value of your estate, there may actually be the obligation to obtain probate of the will, and again, this is a job for the executor and trustee. Probate is essentially the court's approval that the will that the executor and trustee is administering is in fact your last valid will. If you've got any questions in this regard, make sure you raise them as part of the online meeting.
If you have any minor children under 18, Clause 2 allows you to nominate a guardian to take care of them. This clause applies when both biological parents have passed away. You really should be comfortable with who you have nominated for your guardian, including any backups.
The next clause relates to your superannuation savings. Now, as we touched on earlier in the program, superannuation does not automatically form part of your estate. So what we've done under the will, and we'll step through this properly with you in the online meeting, is firstly acknowledge that fact, and then secondly directed the trustee and executor of your will to speak to the trustee of the superannuation fund and work out the most appropriate way to deal with your savings. If you've put in place a binding nomination, this might actually override the provisions of both your will and any instructions or directions that you might have articulated to your trustee. Again, the mechanisms for the way in which a binding nomination might work will be something that we'll walk through with you specifically in relation to your circumstances as part of the online meeting.
The next clause confirms who's going to receive the distribution of any personal items and specific gifts under your will. The will acknowledges that you might make verbal or written directions to your executors and trustees about these personal items, and that indicates that you can use your memo of directions to set out your wishes in this regard. The memo of directions is not legally binding, it is only morally binding, but it is a useful place to put in any directions that you'd like to complement the legal jargon in the will. In relation to your personal items, this is an excellent place to put any items that are of high sentimental value. However, if you have items that are of high financial value, or if you just want complete certainty, then you should include these items in the will as a specific gift. The memo of directions can be updated at any time without having to get a lawyer to sign off on it, so it's a good place to set out some of those other directions that you might like to include.
In many respects, even though it's a really short clause, the net estate provision is the most important provision in the entire document. What it does is take all of your assets, after liabilities are accounted for, and distribute them in accordance with the provisions of the will.
We've given you a cover page which confirms that your will in its draft form reflects your current testamentary intentions, even if it hasn't been formally signed. After your online meeting, we recommend that you sign and date the cover page and staple the draft will to it, which provides a safeguard in case something happens before you get to formally execute your will.
Final part of the will is in relation to the signing and witnessing provisions, and in many respects this is the most important part of the document. Unless you follow the directions that we give you precisely, there's every chance that your will actually be completely invalid despite all of the investment that you've made to this point. The signing instructions that we send out to you will set out a step-by-step process that you absolutely must follow exactly. On the very last page, and unlike a lot of other legal documentation, you actually need to date the document on the day that you sign it and then sign with your normal full signature. Once you've completed this, the two witnesses, who not only must be completely unrelated to you and must be with you through the entire signing process, must sign the very last page with their normal signature and then complete all of their contact details. Unless you follow this process exactly, as I said, there's every chance that your will not be valid. So if you've got any questions at all, please make sure you raise them either as part of the online meeting or contact us separately during the signing process.
Thank you for taking the time to watch this video. We hope you enjoy your online meeting.